A.V. Davis, going both south and east across that intersection. There's an existing good neighbor fence along the west property line of the church, and there is a parking storage area in the northwest corner of the property that appears to be illuminated with an overhead light. There's an existing fence with limited vegetation between the home proposed for demolition and the adjacent single-family dwelling on Lynn Avenue that will remain. The applicant is requesting approval of a conditional use permit and site plan design permit for the expansion of the existing building and a new parking lot. The conditional use permit shall be valid for 10 years from the final decision of the city. The site plan design review permit, as reviewed through this process, is for the entire development. If the applicant chooses to phase the development, or the development is not substantially completed within 2 years of the final decision of the city, the applicant will need to seek approval of an updated site plan and design review permit. Staff met with the applicant and their representative on March 2nd, 2006 to clarify some outstanding issues. The applicant did clarify that the two landscaping plans and the packages will be consolidated and that all code requirements for landscaping, including irrigation, will be met during the engineering plan review. The applicant indicated that the 60% transparency requirement from site plan and design review for the Lynn Avenue facade will be met by additional windows being provided on the facade, and for the A.V. Davis facade, a repeating vertical element will be incorporated into the addition to comply with the massing requirements of the Oregon City Code. The applicant clarified that only 2 sidewalks will be provided through the north parking lot rather than the 4 that are depicted on the site plans. And the applicant has indicated that all lighting requirements for the bicycle parking and the pedestrian walkways will be provided on the revised lighting plan, and that lighting levels for the entire site will be in compliance with the code. What staff would also like to show are the criteria for reviewing the conditional use application. Let's see if we can get it to come up here. There it goes. For the conditional use, there are 5 criteria that need to be addressed. And let's see. And we've laid them out up here on the overhead for you. The first one is that the list is listed as a conditional use in the underlying zoning district, which it is. Churches are identified in 1756, which is our conditional use chapter, and this property is zoned R10, which references chapter 1756. The second is that the characteristics of the site are suitable for the proposed use, considering the size, shape, location, topography, existence of improvements, and natural features. The existing facility is a church right now. It's approximately 5.15 acres. It's built with an existing sanctuary, an outdoor play area, classrooms, offices, a parking lot, and other rooms for miscellaneous uses. The subject site is located on the west side of Lynn Avenue, and it is, as I stated earlier, served by TriMet as well as bicycle lanes. The Oregon City Transportation System Plan identifies Lynn as a minor arterial, A.V. Davis as a collector, and Holmes Lane, just north of the site, as a neighborhood collector. The total acreage of the 3 tax lots for where the proposed expansion and parking lot and demolition of 2 existing homes is approximately 3.2 acres. The applicant has proposed to construct a new facility that will be approximately 94,150 square feet. It will meet all setback requirements for the new building addition. Staff has recommended that the applicant consolidate the tax lots on the north side of A.V. Davis into 1 tax lot. There are no natural features such as wetlands, streams, springs, or slopes on the site. It appears that the size, topography, and shape are adequate and suitable for the expansion of the church and the parking lot. There will be 4 single-family homes directly adjacent to the subject site, of which only the residence located at 910 Lynn Avenue is currently not adjacent to the existing facility and/or parking lot. The majority of this expansion will be along Lynn Avenue,
and the north facade, which will be separated from the residence at 910 Lynn Avenue by approximately 160 feet, which will include the new parking lot and landscaping. It would appear that the location of the church along a minor arterial with a bus route, a collector, and with 4 adjacent single-family homes is an appropriate location for the existing use and proposed expansion. The engineering department has reviewed the adequacy of the sanitary sewer system, stormwater, water, and fire, and there were no significant deficiencies identified. There were minor conditions attached, which are very standard for site plan design review. This would include the signing of a non-remonstrance agreement for all future improvements and any impacts, any upgrades of the systems that would be attributed to the church, compliance with our engineering policies. We've identified that the looped water line should be in a public easement, and any connections thereto shall be provided with backflow preventers, and that the applicant shall submit a final drainage report to the engineering division with the infrastructure construction plans. They did provide a preliminary report, and it appeared that all standards were being met. The third criteria is that the site and proposed development are timely, considering the adequacy of the transportation system, public facilities, and services existing or planned for the area affected by the use. Once again, we are just noting that this conditional use permit will be good for 10 years, and that any, if no work is done within that time period, an additional conditional use permit would need to be approved. There were no major deficiencies identified in the transportation system plan. There was the requirement for an extension of a left turn lane. The applicant had proposed putting in a mid-block crossing across A.V. Davis to the parking lot. In reviewing that, due to the location where that mid-block crossing would be in relation to the intersection, and that this is primarily occurring on a Sunday, the city engineer as well as our traffic engineer felt that it would probably be more dangerous to put in a marked crossing due to the safety that folks feel when they get in those, rather than leaving it unmarked and having the marked crossing at the intersection of Lynn and A.V. Davis. Additionally, the applicant has proposed, and staff agrees, the applicant will be providing no parking signs and striping on A.V. Davis along their frontage on both sides of the street, which should help with the sight vision of folks coming out of the south exit of the building and crossing the street to the parking lot on the south side. We've also required the applicant to provide stop signs from all their exits of their parking lots to public streets, and we've also required that they appropriately mark their access way along the rear of their the church facility as a one-way street, which is how it's marked with paint right now. It will include a sign as well. It appears that with those conditions of approval, the traffic adequacy is addressed per the requirement of this section. Criteria 4 is that the proposed use will not alter the character of the surrounding area in a manner which substantially limits, impairs, or precludes the use of surrounding properties for the primary uses listed in the underlying zone. As stated before, this site has been a church since 1962. The proposed building expansion will increase the building facade approximately 34 feet along the rear or west property line, and the demolition of the 2 existing homes will result in the proposed parking lot being adjacent to the home located at 910 Lynn Avenue. The new north face of the facade will be approximately 160 feet from the 910 Lynn Avenue, a reduction of between 35 to 150 feet, so it'll be that much closer along that side. I have also already walked through that the applicant has agreed that all lighting requirements on the site will be met for both spillover at the property line, which will not exceed 0.5 foot candles, and that all lighting requirements will be met for parking areas pedestrian ways and bicycle parking areas, and those will be provided on the engineered plans should this application be proposed. And I've already walked through staff's recommendation concerning the mid-block crossing that the applicant did propose. Criteria 5 is that the proposal satisfies the goals and policies of the city's comprehensive plan, which apply to the proposed use. I think it's important to note that our Oregon City Municipal Code does implement our comprehensive plan for many issues such as lighting and whatnot. We did walk through the comprehensive plan and try to identify some other policies or goals that may not be directly being addressed in the code or that have been brought up. One has been the noise. Goal 6.4 is to prevent excessive noise that may jeopardize the health, welfare, and safety of the citizens or degrade the quality of life. Policy 6.4.1, provide for noise abatement features such as sound walls, soil berms, vegetation, and setbacks to buffer neighbors from vehicle noise and industrial noises. The applicant, through the expansion of the church as well as the landscaping around the exterior of the site and on the site and within the parking lot, would appear to be reducing the potential vehicular noise from Lynn Avenue to the residential neighbors on the west side of the facility. The commission does have the ability to attach appropriate conditions of approval to a conditional use application, and the code states that the proposed use will not alter the character of the surrounding area in a manner which substantially limits, impairs, or precludes the use of surrounding properties for the primary use listed in the underlying zone, or any other reasonable restriction, condition, or safeguard that would uphold the spirit and intent of the zoning ordinance and mitigate adverse effect upon the neighborhood properties by reason of the use, extension, construction, or alteration allowed as set forth in the findings of the Planning Commission. The Oregon City Municipal Code does not have any standards concerning events that occur within a parking lot and any noise that may be created. One neighbor did bring up the early noise on a weekend morning occurring in the parking lot. Staff did not come up with a recommendation if there should be some type of a time restriction or whatnot. We felt that it doesn't appear that this is a weekly or monthly type of an event. It seems to be based on the schedule submitted by the applicant that these are extremely rare. And with the landscaping proposed, it appears to be mitigating the impact, and without a standard to rely on, we did not recommend one. Does not mean the commission can't come up with one, and we'd be happy to help you if you choose to go down that road. There was some comments brought up about removing the existing housing. Section 10 of the comprehensive plan deals with housing, and goal 10.1 is diverse housing opportunities. And it says to provide for the planning, development, and preservation of a variety of housing types and lot sizes to provide for needed affordable housing. 10.1.1, maintain the existing residential housing stock in established older neighborhoods by maintaining existing comprehensive plan and zoning designations where appropriate. The applicant has proposed to demolish 2 existing homes along Lynn that were built in 1947 and 1953. The applicant has not proposed to change the existing comprehensive plan or zoning designation of the 2 tax lots that the homes are located on. Both of the homes I'm drawing a blank on the exact value that we had on the Clackamas County Tax Assessor data, but they did not qualify as affordable housing. Moving into the site plan design review criteria and the parking, what we have done is we have based the parking standard on the number of seats in the sanctuary, which were 680. In discussions with the applicant, they have indicated that at no time will there be 680 people in the sanctuary. When that is over, those folks moving into the classrooms with 680 people, additional people coming. So the maximum we would have is based on the sanctuary seating. So we did not do a parking total based off the sanctuary seating, plus the classrooms, plus the offices, to come up with our parking calculation and our bicycle parking calculation. Staff would like to point out that based on the parking breakdown provided by the applicant, if you did look at all the uses, that the parking required would be between 235 spaces and a maximum of 677. They've proposed 300, so it would appear that either methodology that would be utilized, the applicant would meet the parking requirements. The minimum, if you just based it on 680 seats, would be 170, and the maximum would be 340. So they do fall within that minimum and maximum under either calculation. The applicant will be providing half-street improvements on Lynn, which does include a travel lane and a bicycle lane, in an attempt to save the existing large trees that are in front of the church along Lynn Avenue. We're going to work with the applicant on the exact right-of-way dedication, because it's going to have to extend a little bit further out to get around some of the trees if necessary when we get into final design. But in general, you're looking at a 7-foot sidewalk along that section, and the 5-foot planter strip will vary depending on the trees, their location, and trying to get that sidewalk a little bit further away from it to provide an appropriate planting in there. As for the parking lot, the applicant shall provide a 6-foot tall fence around the north and west property lines of the parking lot, which are directly adjacent to the R10 zone properties, residential properties. And we have also included conditions of approval concerning the design of the parking lot. The applicant has proposed some compact parking spots, which were under the old code. When we updated it, we went to an 8.5-foot wide by 18-foot deep parking stall, which you may include a 1.5-foot overhang as a condition of approval, and that the drive aisle along the north property line where the buses and vans will be parking needs to be a minimum of 12 feet wide. We've brought these to the attention of the applicant, and it appears that there are no issues with adjusting the parking lot layout to accommodate meeting the code requirements. And all of these would need to be met during the engineering design review before we issued a building permit on this site. So I believe that based on the 19 conditions of approval that have been proposed and the applicant's narrative and submittals, it appears that this application would meet the conditional use criteria as well as the site plan design review criteria, and staff is recommending approval with those conditions. We'd be happy to try and clarify any questions you may have now or help you after the applicant's testimony and public comment.
Thank you, Tony.
And I guess I would like to back up one more time and just have our attorney address the CC&R issue before staff completely concludes.
Thank you. That's an issue that I'm struggling with, so I would appreciate some clarity on that, please.
Okay. I don't know if you want to hear from me now or hear from me later, but I'll give you what I know for right now. There have been a number of correspondence that the city has received from Ms. Hammond and Ms. Durham, who are opponents to this application. And Mr. Hudson, who is the attorney for the applicant, has responded. Neither party has testified before you, so I am gauging all of my responses or summary based on these letters that have gone back and forth. Ms. Hammond and Ms. Durham state that they represent 120 neighborhood residents. One of Ms. Durham's letter follows up, including a list of 78 names. This is taken from the docket of the Miller versus Regal case. I don't know how many of you were on the Planning Commission when Miller was heard, but just to give you a quick summary. An applicant in this neighborhood sought to partition property, and Ms. Durham challenged that partition decision on the grounds that the CCNRs prohibited that partition. The city proceeded to process that application, and Ms. Durham filed an application for declaratory judgment in Clackamas County Circuit Court, saying that the CCNRs prohibited the city from approving that partition application. So what Ms. Durham has submitted here is the docket sheet from that case listing names. It contains 78 names, and it appears that page 2 is missing. We have page 1 and page 3. I suspect it may have been on the back side, but so staff can't tell the Planning Commission right now who exactly Ms. Durham represents other than that. Ms. Hammond and Ms. Durham's objections relate again to these deed restrictions in the conditions, covenants, and restrictions for the neighborhood. They claim that the CCNRs limit development in this neighborhood to single-family residential uses only, and this is the same issue that they raised in the previous partition case. They claim that the city does not have jurisdiction to hear this case because they have appealed the original partition declaratory judgment determination to the Court of Appeals. And I don't know the timing of the litigation because another attorney is representing the city in that litigation. But the case was, my understanding is that the court, and I think Mr. Hudson will be able to explain this better because he is intimately involved in the case, but my understanding is that Judge Van Dyke from Clackamas County determined that the city of Oregon City did not err in proceeding to process that partition application. That it did not have to consider the CCNRs because the CCNRs are not identified criteria to which the application must be judged. That decision has been appealed to the Court of Appeals. Last week, I think it was last week, could have been 10 days ago, the Court of Appeals issued a determination dismissing all of those claims, except for one which deals with a clerical mistake in the judgment. And again, Mr. Hudson's going to have to clarify what that means, but my understanding is that that has nothing to do with whether or not the city erred in processing the partition application when it did that. Ms. Durham's argument is that is on appeal, so the city can't hear this. Ms. Durham filed an emergency stay with the Court of Appeals, my understanding is on Friday, seeking the Court of Appeals to issue an order preventing this commission from hearing this matter. My understanding from talking with the staff attorney at the Court of Appeals is that they have not received that stay yet, so they have not processed it. We have a statutory obligation as a city to process applications in 120 days. We don't have the authority to hold off or to stay an application on our own. That's up to the applicant to make a request. We have an obligation to continue to process the application. Ms. Hammond's second argument, and it's related sort of, but it's kind of different, is that the reason that the link she sees between the CCNRs and the city's review is through the term owner. She argues that easement holders or people who benefit from CCNRs are necessary parties to sign applications as owners. And so she believes that the city has narrowly interpreted owner to mean only the deed holder. This is the exact same question that we went through in the Riggle case, in the partition case, and in that case we made an interpretation as the city attorneys and submitted it as a formal interpretation that the term in the code is record property owner. A record property owner is not a defined term, and we went to Black's Law Dictionary and at the time interpreted it to mean property owner in whose name the title appears in public records. That's the person who holds title, whether or not that's two people or a family or a trust. That's different than somebody who has an easement right, somebody who's subject to CCNRs. That was the interpretation we made at the time. Certainly, the commission is free to change that interpretation if they so choose, but that was the interpretation, and that's an interpretation that the city attorney is recommending the commission adopt today. I'm happy to answer questions, but I'm sure we're going to hear more, and I'll be able to jump in then, too.
Sorry, thank you. Okay, so let's, I guess, step through the, I guess we want to just go through the process to hear again from the applicant, then we'll go through those in favor, those in the middle, and then against.
Yep, and we will leave up the approval criteria. We'd request that any comments made address a criteria for approval or denial.
Thank you.
When public comment is being given.
And I will reiterate that, and the reason I say it is we have, we have limited time, and we heard a lot, and I think we gave everybody an opportunity to talk to us and tell us what their deep inner feelings were, and I appreciate that, and I really do. But what we're making our decisions on are these. We don't make decisions on good neighbors. We don't make decisions on colors of houses or anything else. We make decisions on the criteria that's not there anymore.
I'm sorry.
But will be shortly. So that's what I would like you to keep your comments to, and please direct your comments to this body. Do not direct. I don't want you turning around and talking to anybody in particular. I want you to direct your issues to us. We are the decision makers, and I would appreciate that. And I would appreciate your professionalism. We will give you the time, 3 minutes, to make your comments. For and against, unless you are a recognized neighborhood association, at which point you can take up to 15 minutes for your presentation. Of course, the applicant can take the time that they need to present their case. Am I missing anything? Okay.
You're doing
The applicant
great.
is limited to 15 minutes as well.
Thank you. The applicant is limited to 15 minutes. So that is all I have to say. We'll move forward with the applicant, make their presentation, followed by those in favor of this application. Then we'll talk with folks that have no opinion either way, and then those against. And then we'll give the applicant an opportunity to come back and rebut what he has heard, and then we will close the public hearing if there is time and move forward. Is that clear at all? Great. Then applicant, please come forward. Thank you.
Sure.
We need to start again? Okay. Answer many of the concerns expressed through the actual presentation of the plans which will follow. I will leave that portion of the presentation to the experts. John Moore, our architect, will be making the presentation. Doug Stewart, our civil engineer, is present for questions. Michael Boardman, the landscape architect, is not here. Before their presentation, I'd like to address some of the comments made in public and written testimony. I believe it is most important that I clarify some issues that were raised and address some misunderstandings. At the February 13th Commission meeting, there was a statement made that our plans would change the neighborhood. I suppose in the strictest sense of the word, anything done to any house or other structure in the neighborhood changes the neighborhood. When each home in our area was constructed, it brought a change. Pretty much the only constant in life is change. But as to the character of the neighborhood, we are not proposing a change in character at all. Since 1962, the character of this neighborhood has been that there is a church at the corner of A.B. Davis Road and Lynn Avenue with some businesses across the road, a couple of schools nearby, and residential homes. The church was present and part of the neighborhood when most current residents, including those testifying now, purchased their homes. Our plans do not change the character of the neighborhood. There will still be a church on the corner of A.B. Davis and Lynn Avenue, some businesses across the street, a couple of schools nearby, and residential homes. We believe that the new construction will enhance the appearance of our corner of the neighborhood, and I believe this will be confirmed by the plans you will review. Some concerns were expressed regarding increased traffic. Increased traffic is a condition that exists because Oregon City is a growing community. As a part of our submission, we were required to have a traffic study conducted. This was done not to minimize or avoid the city's code requirements and related standards, but to ensure that we complied with them. We believe we have done this. Some people also expressed concern in regard to cars parking along the street and the need to be careful driving through an area of parked cars. This should be a person's standard practice throughout our city, but there was a concern that people were driving too fast on Davis Road. The staff report is making a condition of approval number 19 to be that the church would place no parking signs on both sides of Davis Road along the church property. It may be that this will actually encourage some drivers to go faster on Davis, and I personally question whether condition of approval number 19 is the best interest of the church or the residents along Davis Road. To my knowledge, and I've been part of this church since before its move to the present location in 1962, I know I don't look that old, but I've been around that long, we have never had a pedestrian or car accident due to people crossing the street to the church. At the February meeting, I was told that cars have been parked in front of homes and possibly damaged some shrubbery. The comments expressed were the first time that I was made aware of any problems, and I apologized at that time. On my watch, and using the words that were addressed to us, I have never blown off the concerns of our neighbors when they were brought to us. It is our desire to minimize and hopefully eliminate similar problems in the future. I will admit that we are an active church striving to serve children, teens, and adults. Therefore, there are events that take place at our church. We strive to recognize the need of our community in carrying out these ministries. I thought I should address some of the comments made about noise from children and motorcycles. Regarding children, we have a vacation Bible school 1 week a year in June, where we have many children come to the church during each day of the week. This is conducted between 8:30 and noon daily, with one evening event which concludes at approximately 9 o'clock. I cannot remember any time that we closed Davis Road. I do remember that one year we had some vacation Bible school exhibits in our parking lot across Davis Road on an evening. I'm not sure if this is the time when it was assumed that we had closed Davis Road or not. Possibly an official search could be made of city records, but we do not recall any time in the last 15 years when Davis Road was closed for any church purposes. It is my understanding that this would not be possible because of the public use of Davis Road. Recently, there was a gathering of motorcycles at our church. So far, we have never investigated nor stipulated how people may arrive to a funeral of one of their friends. We do know that it is our call to help people in time of loss and assist them in recovering from grief. We also have an active youth ministry, a ministry greatly needed in our present American culture, and we believe it is a great asset to Oregon City. Yes, parents do drop off their teens, and some go across the street to Plaid Pantry before coming into youth meetings. We do our best and have basically had no parental complaints to our youth leaders regarding teens going elsewhere once they've arrived at church. Another concern expressed was the issue of present residential properties being off the tax rolls. This is not the case, as the county tax assessor's records will show. At this time, the church owns 5 homes around the church. All 5 of these are currently on the tax rolls, and we annually pay the taxes. We own no, and I repeat no, commercial businesses by which we are making a profit. At present, 2 of these homes are rented out as residences. One is used as a place of prayer, and 2 are provided rent-free to missionaries who are back in the States following their service in another country. One of these mission homes is being offered rent-free to a family in a medical crisis until a missionary arrives in June or July. The church ministry is sustained by the giving of its members and regular attendees, and not through any profit-making enterprises. Now to the gymnasium. A multipurpose room, which will include use as a gymnasium, is a part of the proposed new facility, and we hope will be an integral part of our ongoing service to the families of the Rivercrest area in Oregon City. It will be a place where children and youth can come after school instead of returning to empty homes or wandering the streets. It will be a place where families from Rivercrest could hold family reunions, come to an open gym time, participate in exercise programs, or walk during adverse weather. There are current federal and state studies seeking to address childhood obesity problem in the United States. We believe that we can help address this growing health crisis. Although some may assume that my being on the Oregon City School Board or having the principal of Mount Pleasant a part of our congregation would guarantee our use of a gym, the truth is that we must go through the same avenues as any other citizen of Oregon City in order to rent a gym for church-sponsored youth and family activities. As to lighting concerns around a gymnasium or parking lot, I believe the code changes over the years clearly considered these concerns of neighboring landowners, and that our lighting and landscaping plans more than adequately address the concerns of the neighbors. Finally, and I would like to briefly discuss the issue of the relocation of our parking. It has been our desire to resolve this through a discussion with our community and not through lawyers. But, much to our disappointment, it seems that we are being forced to have legal opinion represented. Therefore, if the members of the Planning Commission would want any response from our legal counsel, Mr. Chip Hudson, concerning the partition lawsuit involving the CC&Rs, we have asked him to be present this evening. First, it must be stated for the benefit of the Planning Commission, our neighbors, and the general public who have been watching this in their homes, we have not hidden our plans away and kept them secret. We have gone more than once to the Rivercrest Neighborhood Association, the only recognized neighborhood association and the only functional association to which we knew to take our plans and present our ideas for expansion. We also invited the neighbors whose property touched our property to an open discussion and dessert in our fellowship center. Our intention is to work with our neighbors for a solution that honors our neighbors and recognizes the needs of the church. Setting aside any questions concerning the interpretation of what the current CC&Rs actually require, we believe that most of the neighborhood supports or is not opposed to the church's plans. Even if it were true that the CC&Rs prohibited some aspects of the church's current design for parking, and we do not believe that this is the case, the CC&Rs contain clear statements regarding the ability of landowners to, by majority vote, and I quote, change the said covenants in part or in whole, in whole or in part. This is number 11 in the CC&Rs, and contained in the CC&Rs is at least one amendment already made to the original CC&Rs. Moreover, without regard to the language of the CC&Rs, the church wants to do everything it can to try to reach a consensus with our neighbors. In our view, the steps we are taking now are only the first part of that process and are focused on ensuring that our plans are consistent with the framework created by the city's codes. While we respect the right of one person to state their wishes, we do not believe that one person can assume to speak for the whole. There is presently no existing mechanism established for an open discussion within the neighborhood. We maintain that this discussion first should continue in the neighborhood rather than the courts. I do not believe that those who framed the CC&Rs envisioned that neighbors would take neighbors to court before there was an opportunity to address possible solutions. I respectfully ask the residents of Rivercrest Addition to pursue an avenue by which we will honor one another as neighbors. Again, I want to thank you for the opportunity to respond to the concerns expressed. I'm going to turn our presentation over to our architect, John Moore. Doug Stewart, our civil engineer, is present. And also, if you want to hear from our attorney, Mr. Chip Hudson, concerning the court litigation, he is present and available to the commission. And just one thing that I would make as a comment, not written, but as I listened to the staff report, there was a statement made that we would never have 600 people go from the sanctuary into the classrooms and have another group come into the sanctuary. I think what I need to clarify is there will be times when there's going to be people in the sanctuary and children in nurseries in classrooms because the adults go to the sanctuary, and there are children that exist in some of those other spaces. The children aren't driving the cars, they're coming with their parents. But I felt like it was correct for me to issue that correction because there will be times when both of those spaces will have some occupancy. But I believe that the staff report correctly looked at those that are driving are the ones that are occupying the sanctuary.
Okay.
Thank you. I'll turn it over to Mr. Moore.
Great. Thank you.
Mr. Hertz memo will be entered as Exhibit B, and the PowerPoint presentation about to be presented will be Exhibit C.
And the what? I'm sorry?
The PowerPoint presentation will be Exhibit C.
Oh, great. Thank you.
Oh. Yeah.
Yep, I got it.
I'm John Moore. I'm architect for Oregon City Evangelical Church, and appreciate the opportunity to talk with everyone this evening about the plans we have. In the interest of time, I'll make it very brief. I know you've seen parts of this before, if not all of it. And so, there we go. Thank you. Thank you. So, first of all, can you hear me okay?
Mm-hmm.
Okay. First of all, to get the orientation correctly, this is north is this way, pointing this way. There's Lynn Avenue right there, and here's A.V. Davis Drive. And this plan is an as-built existing facility plan, and the purple line there represents the existing church. If you went out there today, this is what you'd see. And this represents the trees along Lynn Avenue, the large, some of them 42, 48 inches caliper, and the trees here along this side, and this maple tree over on the northeast corner. And these are the two lots that are in question being presented here by us this evening. And I would ask you to notice the relevant size, or the approximate size of this existing parking lot, that in it has some small planting areas in it, but I think when you see our new parking lot and the character of it, you'll see a marked difference. This is the present entrance from the north side, the main entrance of the church, and in the south side, this is the entrance that goes to the parking lot across the street that we've mentioned today. And this is an entrance here to the educational area and to the senior high area. You'll see how those are developed in just a minute. This is a plan of the property across the street, the parking lot, overflow parking lot. This is A.V. Davis Drive, and this is Lynn Avenue right here. The trees would be right there. And you can see even though this is a construction drawing, it does show the parking layout and the drive-in and the access points. Okay. This is a landscape plan, and the big red line there shows the addition that we are proposing to you this evening. And in the orientation of this particular drawing, north is this way. This is the north face, and here's Lynn Avenue, and A.V. Davis Drive is down here. And this is the existing plan right here, this existing building right here. Now, the main intent of putting this graphic in this particular spot is so you can see the relationship of the parking lot and how large this is by comparison. In the present one, we are parking 72 cars in this existing parking lot. In this one, we're parking only 85, only a difference of 13. But you see the tremendous size here because we're adding another 25% in landscaping and the amenities that make a neighborhood better. And we would be adding a fence down this side as in agreement with one of your conditions of approval, and a fence down this side. And these trees would be 30 feet on center. And these would be trees that would be more mature than the normal development. They would try to present to the community a park-like, pedestrian-friendly atmosphere. Along the further down Lynn Avenue, down toward the A.V. Davis Drive intersection, we have here an area called a meditation court. Now, the relationship to the bus stop, to the transit stop, this is the transit stop area right here, and this is just a short distance away, and there'll be benches, and a large stained glass window that you'll see in just a minute will be right there we have in mind to offer a friendly spot for a pedestrian walking down here to just open up into this courtyard and have benches there that they can appreciate this stained glass window and have a place to wait for the bus and just be a. And one aspect of what we're trying to do with this building is make it very friendly to the newcomer and invite people to join us. This is a blow up of the meditation court to give you more of an idea of what this comes a sidewalk here, and this would be all in here and be stepped, and this is where the stained glass windows will be right here, and you can see the landscaping here, and this, of course, this is A.V. Davis Drive, and this is Lynn Avenue right here in this particular graphic, and that's the sanctuary, the size of the new one, and you can see that the existing one is right in this area right here. It's about a third the size of that. This is a floor plan showing the existing building and including the sanctuary right here. There is actually the dashed line for the present sanctuary, and this is the new one. This will show you how the entrance is, and this is Lynn Avenue here and A.V. Davis Drive here, but you can see that the south entrance that's existing, how the narthex for the church that's existing would be widened a little bit, and all of this would be new out here and widened, and would connect one entrance on the north side opposite the new parking lot with the south entrance here, where we have an equal way to go either direction. And this shows the entrance around here at the senior high room and the way the parking would be. And you see again the green areas here, only they're not as specific as the landscape plan. And here is the meditation court right here. Okay. Now this is the east elevation that's along Lynn Avenue, and in a sketch of the trees here, try to depict the character, because the top of that gable right there is 35 feet, and that's a fairly large area there, but the way the trees are there, they break up this whole form, and where it's nestled in with the trees. I'm not sure I make myself clear with that, but it's would be not anywhere near as effective from an artistic standpoint if the trees weren't there, is what I'm saying, and the stained glass window were not there. Now, as part of a condition, we talked with Tony about placing some gable points at each of the entrance. We have an entrance here, and we have an entrance here, and where this is coming from, you'll see just a minute the south elevation, and you'll see a gable over the entrance. We're using that form as a place to enter the building. We're using it as a place that's a most important space to recognize to enter the building as part of the welcoming process that we feel is part of the theme of this building. And you'll see around here on the north elevation, we have the same kind of thing that's top lighted so that light comes through the stained glass window there. This is educational over here, and this glass along here. This is, by the way, a material board that I brought along, and I'll flash that to you in just a minute. You can see stained glass, and what the major material there is a white brick that we try to give a more permanent material than the wood, but we want to tie it to the existing lap siding, and so we're trying to make a transition with those. We think that is going to be a very effective elevation from an artistic standpoint. This is the north parking lot, and this is the entrance. It's a two-story entrance there, so that this can be seen down the corridor, and the light passing through that can help light the corridor. And it's also top lighted. This is the top lighting for the Lynn Avenue Street side. Now this is the elevation that's off of parking lot on the north side, and this is educational and administrative. This is administrative here and educational down here. This is the south elevation, and this form is in place, and that's what I was speaking of a while ago when we have these at entrances around the building. And and it also has stained glass in it presently. And so we're trying to keep some of the form that we have present and extend that into the new building and offer more of a welcoming, enriching entrances. Next slide, please. That concludes my very brief presentation to you. I hope I hit it close to what I was allowed, but I want to offer you this up close real quick, and then turn the meeting over to you.
This is already in the record. It was a requirement of the application.
I don't have anything else at this point. There are some folks from our church, I think, that we've advised them just to write out their comments so they can turn them in as written documents rather than taking the time of the commission to present those now.
I would be interested in the attorney's comments, and I know we're over our 50 minutes, but if the commission doesn't have to do that, I would like to be there.
Thank you, Commissioners. My name is Chip Hudson, and I have represented the Oregon City Evangelical Church in this court case that you've heard about, Miller v. Riggle. I've been asked to comment, have submitted written comment in response to some of the comments submitted by Ms. Durham and Ms. Hammond. And I'm really here to respond to questions and to respond to the arguments that have been presented concerning the Commission's jurisdiction. And my wish is to be as brief as possible and to take only the time that will be helpful to all of you. And so I've tried to organize in outline form a few comments that I hope will help make sense of this. But if any of you have questions as I try to march through this, please interrupt me, and I really invite that so that I'm clear. The issue, as I understand the argument that's been presented, is that the Commission does not have jurisdiction because the issue of the CC&R enforcement is pending in the courts. And I'll discuss in a minute. I don't think very much of it is still pending, but the appeal isn't finally concluded. So in that sense, I think there's still something left. I think that the most important point is the point that the city attorney has already made, and that is that the CC&Rs, we're really talking about two worlds here. The CC&Rs are deed restrictions that are a private contractual matter, and as such are enforced or not enforced by the courts. In contrast to that, you have the work of this commission and similar land use bodies, which is really concerned with code compliance, with the application of publicly enacted, legislatively enacted code provisions. Those are two separate sets of issues. They follow two separate sets of appeals. Ironically, I think the argument that Ms. Durham makes now is the same argument that was made when the city considered land use applications for some of the parties that later became involved in the Miller v. Riggle case. And I want to make very clear that we were talking about, again, two forums here. And I wasn't involved at all with the land use process, and I'm not primarily a land use lawyer, but my understanding is that some of the people in the Rivercrest neighborhood wanted to partition their homes, their residential properties, so that they could construct a second residence on on certain lots by subdividing them, and that they came through the land use process to seek the code approvals necessary to do that, and that at that point, one of the lead plaintiffs in the Miller v. Regal subsequent court litigation opposed that before the commission and argued that it shouldn't be permitted because of CC&Rs, that in the party's view precluded this kind of subdivision, again, a private contractual matter. The city determined at that point, we believe correctly, that that was a private contractual matter, that was not a part of the commission's responsibility or even ability, jurisdictional ability to address. And therefore, the city considered the applications and declined to consider and apply the CC&Rs. Subsequent to that, a lawsuit was commenced, Miller v. Regal in Clackamas County Circuit Court, seeking enforcement of the CC&Rs in that format. And the issue presented in that case, in my view, there were two. Originally, there was the issue of whether the partitions that were proposed violated the CC&Rs of the Rivercrest Edition, and then second, via an amended complaint, the plaintiffs in that case asserted claims, including damage claims, against the city of Oregon City, essentially arguing or based on its alleged failure to enforce the CC&Rs in the land use process. Those claims were dismissed by Judge Van Dyke in the Circuit Court twice. The second time they were dismissed, the court found that they were frivolous and lacked an objective, reasonable basis to be pursued, and that in turn was the basis for an attorney's fee award in favor of the city. That award has not yet been reduced to a judgment. A judgment's been submitted, and I would expect probably will get entered in the next week or two. The result of which will be that there'll be a lien for something like $20,000 on the homes of the parties participating as plaintiffs. That the other part of the case, the partition case, went to a trial, and at the trial, the court ultimately interpreted the language in a way that was adverse to the plaintiffs, but it made that decision. That judgment, which then included the dismissal of the claims against the city and included the court's determination interpreting the CC&Rs as to this partition issue and dismissing all other claims in the case, was appealed. And about a week ago, the Oregon Court of Appeals, in response to both a motion by Ms. Durham and her co-counsel to ask the court to determine as a preliminary matter jurisdiction for the appeal, and as a result of the defendant's respondents in that case, motion to dismiss the appeal, the court dismissed the appeal from the judgment that was entered as untimely. What remains, and they concluded in the process of ruling on the appellant's motion, on Ms. Durham's motion, to determine the appealability of the judgment, that it was appealable because it represented a sufficiently complete final judgment. There's a legal issue that sometimes gets raised as to whether a judgment is complete in the sense that it addresses or disposes of all the claims that are raised in the case. The Court of Appeals determined that this judgment did. What is remaining open in the Court of Appeals now is an appeal from the Miller v. Regal plaintiff's motion in the trial court to set aside that judgment. Now that, as a preliminary jurisdictional matter, the Court of Appeals has determined that the appeal from that order was timely. It was filed within the time limit for appeal of 30 days. And so, at least on a preliminary basis, the court is indicating that that will need to go to a further review on the merits. I submit, and again, this, I mean, need to make clear, this is my legal analysis as an advocate. But I think it is also apparent when one understands the case and reads the Court of Appeals order dismissing and addressing the motion to determine appealability, that the only issue on which that motion to set aside the judgment was made was again this issue of whether the judgment should be considered void because it failed to address in some fashion all of the claims that were presented. And that is the same issue that the court has ruled against Ms. Durham's arguments on this preliminary threshold area of determining whether the judgment's appealable. Because, I mean, and this is, I find it difficult to explain, but it's one of those things about the legal process that everything follows certain procedures and is considered at different stages. So on a procedural level, nonetheless, that appeal from that order denying the motion to set aside was timely, and therefore, absent some further ruling of the court, it will go forward to be briefed on the merits and potentially have oral argument and ultimately result in a decision. My own view is the decision is fairly clear unless the court somehow reverses the reasoning that it's already adopted in ruling on this preliminary appealability issue, but only because of the grounds that were actually raised in the trial court that remain to form the basis of some appeal. That may be more than you wanted to hear about Miller v. Riggle, but that I should just stop there and see if there are questions perhaps before I move on to the last 2 points I have.
Well, cleared it right up for me.
Got it here.
No, I guess what, I guess when it comes down to my decision, on this as this board, is understanding more about what is open, and which you've done a good job of explaining. I'll hear both sides of that, and what the city's attorney's position is on how that affects us as a decision-making body. That's what I want to get out of between the three discussions we have this evening. And I mean, history. Thank you. It's a moot point at this point in my mind. The decision's been made, and that's the way. We do have an open presentation here, and I want to hear more about that. Other than that, unless.
Well, I'm just curious, in your opinion, if the city were to lose the appeal right now, what would the effect be on this particular application and on the Planning Commission itself?
None at all, in my view, because the question the remedy is pursuit of enforcement in the courts, and your decision on code compliance is an entirely different matter, and from which an appeal would run to LUBA, and then on in the normal course and get its way to the Court of Appeals if it comes to that. But in my view, Oregon law, and we've cited one case in the written materials submitted, is pretty clear on 2 points. One, that there is this separation, that this is a matter of, application of code is separate from the private contractual enforceability of CC&Rs. And second, I think it's also clear that to the extent that any court's decision would matter to you one way or another, the existing decision is a judgment that is against Ms. Durham and her clients on this very issue. And that judgment is binding as a matter of collateral estoppel or res judicata, claim or issue preclusion, until and unless it were reversed by the Court of Appeals. But it has that binding effect now. So if one were to go into any trial court on this issue, this question would be already decided against Ms. Durham's clients.
And is there any other?
Well, there are
Point-
just two other points that I think I can make much more briefly.
Okay.
I think the city attorney gave you a very good description of what I consider sort of the other argument here on what the code should mean with respect to record owner. The only thing I would add to that in support of the definition that's been selected as being the logical, rational one is that if you were to accept the alternative definition that somehow any kind of covenant deed restriction should be considered a species of ownership, then the result is that any kind of land use application would require everyone in the neighborhood not simply to waive, but to actually affirmatively sign in support. I mean, it would give all of the neighbors, all of Ms. Durham's clients, the ability to veto anything any other one of them wanted to do, and it's not a sensible interpretation of code for that reason. The final point, which I think is very important to my client, just to be clear, and I want to respect the fact that Ms. Durham and I may have some differences as to what the scope of the litigation is and what issues were raised or not raised within it. But I'm very concerned by the statement made in the original written letter that she and Ms. Hammond submitted that she represents 120 Rivercrest residents who object to and are opposed to the church's application, because I feel that that's simply inaccurate. If by that she's intending to represent to you that she represents those parties for the purposes of this proceeding, and if that is the case, then I would urge you that it is necessary that her clients be specifically identified. What's been submitted is simply a roster, which admittedly includes some inaccuracies, but neither here nor there, of all the people who were parties for purposes of the Miller v. Riggle litigation. And that is not the same thing. I mean, if she's intending to offer it only in that sense, then I don't have a way to get behind that and question it. But if she's saying that every one of those people object to the church's plans, then I have a problem with that, and I think that just due process and a clear decision requires that those parties who are objecting be individually identified in a different way than has been done. Thank you very much.
Okay. So that's it for the applicant at this point?
Is there a process, or should those that have written testimony just hand them to the Tony? Is that the process?
Yeah. Is that, would you like to do, Tony?
Commission's got to make a decision here about whether or not they're going to make a decision tonight or hear more. Mike, my assumption was that the commission was going to make a decision tonight. If the applicant wishes to submit more written testimony, that's fine. What we could do is go into that 7-7 thing, dance that we do at the end of these quasi-judicial hearings. But we would need the applicant to extend the 120 days in order to give the city enough time to process an appeal should one come. So it's the commission's pleasure, but we do need to either hear from the people that are here tonight, go ahead and close it, or get their written submissions and extend the 120 days so we can do this in writing before the record's closed. So,
Gotcha.
I think in response to that, Mr. Powell, I'm not sure that I don't know from those that have brought written testimony if they would be addressing one of these 5 criteria, and that's why I wasn't going to have them come and you've heard a lot about what we do as a church. You've gotten a lot of written documents already, so I think many of their comments were in that same vein, and they wouldn't necessarily have addressed one of these 5 criteria, so that's why I wasn't going to have them take the time of the commission to share those.
And what is your take on extending that time limit?
I think for our purposes, we'd prefer to see the action of the commission.
Okay. I'm fine with that. I mean, that means, and I want to make sure that everybody understands that that what you have this evening, and if it meets one of those requirements, I'm happy to hear it. If it's not, if it's something that doesn't, then that won't be heard, or it won't be entered into the file. So,
Part of your decision, probably.
I'm sorry.
Part of your we take comments and try to apply them to an approval criteria.
Right.
So you'll hear them, and they'll be in the record. And
But if it's submitted after tonight, and we close the public hearing, it will not.
correct.
I guess that's what I was trying to
Yep.
say, but mouth didn't work quite as well as I thought.
And if folks would like to come up, need to
So-
let them.
Right. So if anyone in the audience would like to come forward
And speak in favor of the application.
and speak in favor of the application and have your comments meet one of those requirements, please do so. Okay? Now, we will call for anyone who same situation, who is neither for nor against. Okay, seeing none, we'll move next on to those who are against this application. You submitted a note to Tony, did you not, with your name?
We have some written materials. The record is fairly replete. Thank you, gentlemen. It's growing late. I will try not to take much time. While I take issue with the factual presentation of Ms. Richter and some of the legal analysis of both Ms. Richter and Mr. Hudson, and this is an area where reasonable minds can differ, and I respectfully disagree with them, I am not going to put you through the argument that we are presenting before the Court of Appeals. Rather, I would like to address criteria number 4. I'm sure most of you have, or if you haven't, will drive down the corner of Lynn Avenue and A.V. Davis and take a look at the little church that has been there and grown a bit, and make note of the fact, as has been testified tonight, that they own not 2 but 5 houses, 2 of which are currently scheduled to turn into parking lots. Now, we've addressed to some degree the issue of the CC&Rs. You asked a very interesting question, Mr. Powell, I believe it was you, as to what impact this might have on any of you making this decision. And while I'm not here to give you legal advice, I would draw your attention to the statutes implementing the 14th Amendment in the aftermath of the Civil War, many of which start out, "Whosoever under color of state law shall deprive a person." And there are quite a number of them. What we have here is a public policy in the state of Oregon that protects the constitutional property rights of individuals in planned unit developments. Now, I like Black's Law Dictionary as well as anybody, and most courts will use it as one of many persuasive resources, but it is not the law. So I would like to read for you very, very briefly the Supreme Court take on this particular matter. It comes from Westwood Homeowners Association Incorporated versus Lynn County. You can see it's only this big, so we're not doing a big thing here. The citation is 318 OR 146 at page 153. Each lot within Westwood PUD is therefore both the dominant and the servient estate or tenement with respect to the CCRs involved. The benefits and burdens of mutual promises attached to the ownership of each lot. Skipping some down, ORS 94.560, subsection 5, expresses a strong public policy in favor of preserving the valuable interests of such servitudes, protecting the expectation of owners, and preventing damage to the private land use planning programs. And then they go forward, this is a tax case, a tax foreclosure that extinguishes servitudes of the dominant estate arguably would infringe on the constitutional rights of the owners of the dominant tenements, depriving them of their property without due process of law. Now, very briefly, CC&Rs are covenants running with the land. Every homeowner holds a dominant estate in every other house subject to those CC&Rs. Every homeowner has a right to enforce those, and it only takes one. And I would like to tell you, first of all, we will provide you with the information about the clients who have retained me for the purpose not of the Miller v. Riggle litigation, but to protect their constitutionally protected property rights under their CCNRs, their ownership of estates in land, dominant estates, including those of the church property. Now, we saw some very pretty pictures in the architectural presentation, and I think you will notice, first of all, if you drive down there, that the proposed change is dramatic, and in fact puts a version of a megachurch on a corner where a small little church has been in a residential neighborhood for a while. It changes the character dramatically. But I don't want to talk about that as much as I want to talk about my clients, Mr. and Mrs. Kornblum, who have lived many years at 910 A.V. Davis. Mr. Kornblum is 91. Mrs. Kornblum is 82. They have one wish, which all of us should be blessed to have granted within our lives, and that is the right to die in peace, to live out their given time on this earth in their own homes. Now, as it happens, that lovely landscape parking lot has a bus lane where the buses with the big diesel engines and the fumes are going to start and stop and park and warm up their engines right next to Mr. and Mrs. Kornblum's house. I have had frantic telephone calls from their son, who is fearful that this will kill them. The CCNRs that protect this neighborhood, criterion number 4, which defines what you may do, comes down to a basic point. A residential neighborhood is not a parking lot. And this parking lot is not just the parking lot for the church, because there is a whole gymnasium and an entire thing that is going to be going on at very many hours of the week. And while I applaud the church's high motives, I think they need to find other land that is not constitutionally protected with people's property rights and the state policy of the state of Oregon to do their parking. Because if they have events at the basketball game, do you think the people won't be putting buses under the Kornblum's bedroom window and leaving at 10 o'clock at night after the game? These are the citizens you are here to protect. Criteria 4, which must be met in this application under the plans that are put forward here, fundamentally, absolutely, completely, and totally changes the character of that community, and a 6-foot fence won't help. And it's going to be, in a few years, 3 more houses. But by that time, we will have had something I moved back here from New York to get away. The salami tactic. You cut off a little here, and then a little here, and then a little here, and pretty soon, you know what? You don't have the salami anymore. All you've got's the bitter end. And that's what we're looking at here. We're building a megachurch with a commercial facility adjacent on land that is not subject to CCNRs. I frankly have no opinion about what they do elsewhere. My clients, and especially Mr. and Mrs. Kornblum, don't need to have their lives deteriorated and degraded by this kind of dramatic change when they paid for, own, and enjoy rights protected under Oregon law, the Oregon State Constitution, federal law, and the Constitution of the United States. And I ask you, gentlemen, please, I promised their son I would be here for you tonight. And drive by there. Remember these pictures. This is a huge change in the character of this neighborhood, and a parking lot is not a residential use. Thank you.
Thank you. Okay, any questions? Well, no, all right. Any other comments opposed to this application? No? Okay. Well, then, if that's the case, I will close the public hearing. Oh, I'm sorry. Oh, gosh, I forgot. Sorry. The applicant does have a chance to rebut, if you'd like to do so. Sure you can.
I believe I'd just like to mention 4 things in response. Again, as the church would like to enter into an open discussion with our neighborhood, not them nor we going door to door, presenting only our opinion and not representing, having an opportunity for the asking of questions and discussion. So I would maintain that I still question if there are that many residents that have a clear understanding of the case to be able to respond. Second, I guess that's kind of my first 2 items. In regard to the bus parking next to the Kornblum's home, I believe if you look at the site plan, the actual parking area for the buses is more towards the rear side of that parking area. There is a van parking space closer to the Kornblums, but their home is very close to Lynn Avenue. There is actually a second home constructed on the back part of their property, and yes, the buses would be closer to that, but that is not the residence of the Kornblums. I'm not sure who lives in that second residence. And I would again just maintain that we are not changing the character of the neighborhood. There will be a different size facility there, but the character of the neighborhood, as I mentioned in my opening comments, contained a church and a parking area with businesses across the street, some schools nearby, and some residences around it. The neighborhood stays the same. And so I respectfully just submit those comments back to you.
Okay, thank you very much. Okay, so we've gotten all the input, I think, now. And at this point, I will close the public hearing, and we will now take it up to the commission for discussion. Gentlemen?
Making sure that we get the sidewalk in the public right of way,
Okay.
rather than on private property.
So the trees are staying,
Correct.
and so it's going to have to move more towards the church then.
A little bit further west, that's correct.
Okay. Who'd like to start?
I had some questions for Pastor Hurt.
Well, actually, we've closed the public hearing.
Oh, so can I?
Can't unless we open the public hearing again, which we can certainly do. If you'd like, if it's important that you get those answers, we could reopen the public hearing.
I would like to do that, then, please.
And the issue with the reopening, no issue at this point with you guys?
No.
Okay.
As long as we hear from everybody who wants to comment
I-
in response to any questions you ask.
That would be the criteria. Okay, so we will reopen the public hearing, and
Thank you.
your questions.
Pastor Hurt,
Yes.
how many people in the neighborhood go to your church?
There were as I can't identify. If you consider the Rivercrest addition, then that's one criteria. If you look at the neighborhood on both sides of the street of Lynn Avenue and both sides of Davis Road, that number changes.
Yeah. So would you say that the church draws from a greater area than the neighborhood?
Oh, definitely.
Okay. And most of the people coming to the church are arriving by car?
I would say the vast majority, yes.
There aren't a lot of people that walk to church.
when you look at the number of people coming, I would say it's a minority, that for sure a minority that's walking. And I think that sometimes I live several blocks away. When the weather's nicer, I walk, and my family will walk with me, and others will walk. But in what is many times the Oregon climate, I would say during those times,
Sure.
fewer people walk.
How many folks do you have coming to the main worship service on Sundays at the moment?
Presently,
Yes.
we have 3 different worship service hours. So there's anywhere from 200 to 350, depending on which service.
All right, so total is, I think you said 600.
Between 600 and
Yeah. And
Yep.
you see that pretty much doubling with the additions to the church and everything.
as far as the sanctuary seating
Yes.
capacity, yes.
Yeah. Yeah.
At this present time, we don't see that we would have 3 services on a Sunday. Because of having more seating space, we would be reducing by 1 service.
Okay, that's all. Thanks.
Okay.
Any other questions? While you're up there?
Yeah.
Okay. All right, that's it.
Thank you. Sorry.
Want to hear from anybody else who wants to rebut or?
I'll ask the question. Anyone like to ask any questions, what you heard from that discussion? No? All right. I don't think so. I think we're good. So at this point, now I'm going to close the public hearing again. And we will come back up to the commission for discussion.
Okay, I'll take a stab at it.
All right.
I think criteria 1, 2, 3, and 5 are fine. 4 is the one where I'm concerned for a number of reasons. One is safety. The amount of traffic around a facility like this is pretty immense, and having lived in an area around Willamette Falls Hospital can be very dangerous. So I like the fact that the staff put in 19 as a condition of approval. I think it's an important one where you knock off the parking near all the traffic with people and cars. I think it's a great idea. The noise is something that concerns me as well, but I think the fence and some of the things that have been put in here at least address that. And there's still going to be problems. Yeah, there's no way you can control that totally, but I think I feel a lot better now about what's going on as far as the church construction or this proposal than I did before. So that's where I'm at right now.
All right.
My main concern is what happens when a neighborhood church turns into or begins to turn into a regional church, and it loses that, it grows beyond its neighborhood. So that's my concern is with this proposal.
And I would say, if we look at the facts, and that's what we have to make our decisions based on, the facts of the traffic pattern say it makes no big difference. The facts of the noise and the abatement, maybe it makes no big difference at this point. So I guess to look, if you're looking 10, 15 years down the road, it's hard to know what this decision we make today will come. And I guess that's what we have to look at. I mean, we really can't look so far out and say, well, what happens if Oregon City triples in size? Well, who knows? We don't know what's going to happen at that point. We have to base our decisions on the facts we have today. Is my take on this. So to your point, if it becomes a regional facility at some point, or maybe it will, maybe it won't. But
Well, and I'm speaking of what's proposed now. It's grown beyond just a neighborhood church. see how you can call a place that can hold almost 1,000 people a neighborhood church anymore. And it alters the neighborhood significantly.
Well, in some cases that's true. I would also argue that a neighborhood church isn't just for a neighborhood. A neighborhood church addresses many neighborhoods, and all of our neighborhoods commingle. And so this particular church will reach out to many neighborhoods, as do many churches in my neighborhood, for instance, reach out and pull people from all of the different areas. So I'm not sure I'd call it a regional church. I don't know that I see people from Beaverton driving out here. Maybe they do, I don't know. But, I still see it somewhat at least for this application, I still see it as a neighborhood church. I'm just giving you my thoughts.
Okay.
Well, for me, actually, I've got a lot written down, made some notes and everything. But actually, for all the emotion, for everything that I've heard, this is actually quite an easy decision for me. I have absolutely no problem with this application. Absolutely none. I think all 5 have been easily satisfied, and then some. Really, that's it for me.
Well, that puts it right in a nutshell then. So here's what I'd like to talk about a little bit. I had some issues. The first issue I had was the legal piece. I got a good reading from our city attorney. I got a reading from the applicant's attorney, and I didn't really get the rebuttal that I thought I would get from the other attorneys. So I have a higher level of comfort now with that decision. I'm a little disappointed that the discussion with the neighborhood happened after the fact, and I maybe I misread that, but when and I don't remember, one of your trustees came before us last meeting and said, well, we're going out now and talking to the neighborhood. Too little too late, I'm afraid, and that is unfortunate. Being a neighborhood advocate as I am, I really wish that those things could be done up front, and I'm sure you probably in hindsight do as well. But I think a lot of these issues could have been resolved, at least the emotional issue piece could have been resolved by having some discussion with some of these folks early on. Saying that, that's not going to change my opinion at this point. But what I do have a concern about, and maybe this is something we can talk a little further, and 19 it talks a little bit about it, but I'm concerned about what I heard from some of the neighbors about the parking and how that area is used. Now, I understand maybe it's only on Sunday, but it is an impact, and I think by putting no parking signs on A.V. Davis Road along the church property is just going to force everybody back into the neighborhood, and that concerns me a little bit. I think it's not going to solve the problem. I think it's going to hurt you more. Exactly. So I guess it makes sense to me to change or to have no parking signs where it comes out onto Lynn, so you can actually have good visibility. I'm just a little concerned about putting this particular criteria on it, because it just I think it's just going to make it worse. What do you?
Well, I guess from personal experience, definitely on the parking lot side, that has to be no parking, because you have 3 exits coming out of that parking lot, I think, on 2. There need to be some, when people are pulling out and you've got traffic turning in, you've got a lot of people moving right there. At least that side within, I don't know, 150 feet. I don't know what you need for the site.
Site distance?
What's that?
For the site distance?
Yeah.
Okay.
But definitely on the parking lot side. The other side, probably by the entrance at least, or the main entrance that you have there.
Mm-hmm.
I think you want no parking there. But, if I understand what you're saying, and probably further down, A.V. Davis would be okay.
And I guess that what I would suggest is perhaps the church have monitors on the busy Sundays where they're walking out in that area and making sure that the neighbors aren't impacted, and that might be a real nice neighborly thing to do, and it might help go a long way in building that relationship back with the neighbors. And I think I'm not suggesting that you've ruined your position in the neighborhood, because I don't think that's the case. I think that there's some misunderstandings there, And I think some of these real simple things could be done and help that along the way. As for, I think 1, 2, 3, and 5 were met, and I think they were met completely. 4, I was a little concerned, but what I have to look at, and what I did look at, was when I sat up there and I sat across from the church, and I really tried to picture this in my head, and I really see it as a transition. I see it as a transition from a commercial piece across the street into the church and surrounding areas, and then into the neighborhoods. I don't see it as a big mega church being dropped into a little slot. I think the impact initially will be a big impact, but I think overall, I don't think it's going to be a huge long-term impact for the neighborhood. I think it'll be, if it's done properly and follows the criteria and the design plans that we have set up, I think it will enhance the neighborhood in the long run. And I applaud. One of the things that I really think is important, and I applaud the church for staying in the neighborhood, because one of the things that concerns me a lot about what's happening in Oregon City, the schools are moving out of the neighborhoods. The churches are looking at bigger and better and mega churches outside the neighborhood, and you know what? That is what makes a neighborhood. Houses don't just make the neighborhood, and I think we have to look at that, and I look at that in every decision I make in this community, because that's what this community is about. And so, I support the application. I think it's a good plan. I wish you well in your growth. Your church has done a lot to help this community, as have many of the other churches in this neighborhood, in the neighborhoods. So, with that, I will leave it open to you folks. So, Tony, comment?
Just in hearing some of the comments that are being made, trying to brainstorm a couple ideas, maybe help you out a little bit as well. We might be able to amend 19 if you're concerned about the parking, and leave it more to the city engineer rather than just making a blanket no parking on either side of the road. Leave it to the city engineer to be able to review it, stay on top of it, and appropriately sign and stripe the area in cooperation with the neighbors in the church, rather than just saying no parking on either side.
Yeah, and I would say, it makes safety the key.
Yes.
I mean, safety is the key in my mind. And let the church deal with the issues of their parishioners parking in other people's, but that's not our issue. I think that should be up to the church, and let them build that good neighbors back. Mm-hmm. I don't know that we need to put that in here.
Okay. We also came up with potentially residential parking only on Sundays between X and Y could be an option, with signs further down A.V. Davis. We could also try and craft some language that the church will work to make sure that their parishioners, users, don't park down there, and we can revisit the issue in 6 months or 12 months and see how we're doing. So we have a couple options that we could probably try and pursue
It may
if you
be
desire.
more than just Sundays. I mean, if you've
Oh,
got,
certainly.
if you've got basketball events or events in the gymnasium going on that are going to bring hundreds of people into the neighborhood. I mean, you need to look at all of the possibilities of disruption in the local neighborhoods that the church may have. If you got Vacation Bible School with hundreds of people coming in and things like that. So maybe working with the church to identify those events that may need some enforcement for the neighborhood.
Is that clear? It's hard. I think it's hard to say work with the church to identify. I think we have to be a little more clear in how we present that, especially if we make it a condition of approval.
Right.
And so I guess what I know what you're saying, and I don't know how to get around that. I think that really the key is, I think we have to leave it up. I would recommend anyway that we leave it up to the city engineer, but in discussion with the church, because I think there's some issues that have been brought up that I think we need to discuss, and I think that's just what we're hearing here, that there's it's just not on Sunday, it's on other days of the week, and with this community room, it could cause problems later into the evenings and things like that.
Well, what we What you might do is, put a condition that the church meet with the neighborhood in 6 months and discuss the issue, and then bring a report to the city engineer. And if the city engineer feels that it's an issue still, could bring it before the commission again, and we could reopen the issue and talk about what mitigation might be appropriate at that time.
I would be fine with that.
I don't know, would the applicant, they could nod their head, or,
Not really, actually, can you?
well, no, but go ahead.
The question that, we would just like you to tell us, when you say talk to the neighborhood, there's two different groups here. There's the neighborhood association, Rivercrest Neighborhood Association. We've gone to them multiple times. We're glad, we'll go to them about this, if that's the organization you mean. If you mean the Rivercrest Addition neighborhood, there's no established
Understand.
group. So that's just where we would need clarification with you as to, or if it means work with your neighbors on Davis Road and Lynn Avenue and Holmes Lane, then that gives us
I think that's more.
that gives us a subset that we know that's who you want us to talk to.
Well, and here are our options, I guess, is we could contact have the staff contact the recognized neighborhood association and say, you need to get involved in this decision, which they've already said they don't want to be involved in that decision. So I say we'd probably drop that. I think that probably the good recommendation would be that to meet with your neighbors on the surrounding streets.
Right.
And I'm not sure we can define those.
It seems to be just A.V. Davis is the issue.
Well, that's what all I've heard.
Correct.
Is A.V. Davis. So and if that's the issue,
And based on what comments we've had, that would be our recommendation, is to work with the property
Done.
owners directly affected.
I'm fine with that, because that's what we'll try to get to. So if we could put that in we'll put that in as 20.
Or were you going to modify 19?
Should we modify
modify
19 so
19?
that we have some flexibility instead
Sure.
of just no parking on either sides?
Yeah,
Okay.
as you, well, I'm don't make all
Yeah.
decisions for this, but as you.
Well, I have the applicant shall work with the city engineer and interested neighbors to,
Or property owners on A.V. Davis.
Yeah. That would be better. That- Okay.
can you read that back?
The applicant shall work with the city engineer and property owners on A.V. Davis to address parking.
Parking concerns, parking and safety issues, I would say. Safety's part of the issue.
Parking and safety.
Okay.
I guess, if we can work through if there are going to be any other conditions, if you guys want to, if the commission would like to discuss that, and then maybe give us just a second to just think it through real quick and try and rewrite it a little bit.
I'll bring it up. The only other issue that I had is, because it annoys me to no end, is to have buses idling out in close proximity to where I sit or where I'm at. And I don't know if there's a way to fix that. I'm guessing there is. Perhaps we choose a site that's not so close to any residential areas to have them start up and run or idle. If that would, if we could work on that as well, and I'm not sure I don't even know that I'd put that in as a, I guess I offer that as a suggestion. Any more? Want to add?
Nope.
No, thank you. All right. Okay, so what'd you find? Did I give you enough time?
Did we miss something about a bus condition?
No, we're not making a condition.
We were just venting about buses.
I was venting about buses.
Gotcha. I was going to ask you how that related to the criteria, but
It had absolutely nothing. I just felt I was giving you a little time.
Tony's scribbling furiously. So
Okay.
So we have just one amendment, removal of 19 and addition of the revised language.
And we'll hear that. So we meet your requirements. Thank you all for your patience. See how long it takes. Okay, how you doing there, Tony?
We're good.
All right.
We would recommend amending condition 19. The applicant shall work with the city engineer and property owners on A.V. Davis Road to address parking and safety issues. The applicant shall pay for all signs, curb painting on both sides of A.V. Davis Road to allow adequate sight distance and address the identified parking and safety issues.
Identified by the city engineer.
Is there a time period attached to this? Does there need to be? I mean,
Well,
say
the-
we're-
The review in 6 months. I
okay, is
think.
that,
We can put that in.
Just add that, and that's, I think that'll cover it. We can reread that for the applicant.
Within 6 months after approval, or within 6 months after the decision is final, the applicant shall meet with the city engineer and, what's that word say? The applicant shall work with the city engineer
And
and
property owners.
property owners on A.V. Davis to address parking and safety issues. The applicant shall pay for all signs, curb, painting on both sides of A.V. Davis to allow adequate sight distance and address the identified parking and safety issues as identified by the city engineer.
That's good for me.
good.
Okay. Is that how it stands? All right.
Shall I move then?
Please.
I move to approve CU 0504 and SB 0525 with the amendment that Tony just read there for number 19, as well as the rest of the conditions of approval.
Second.
All right. Did you get that motion and second?
Okay. Commissioner Lejoie,
Aye.
Commissioner Dunn,
Aye.
Commissioner Roddy,
Aye.
Chairperson Paul.
Aye.
Motion carries 4-0.
Thank you very much. Thank you all for coming out for 3 or 4 meetings. We appreciate your patience and having you all here. Thanks.
2-0 Wednesday. Tomorrow. We'll most likely send out the notice of decision on Wednesday
Okay.
of this week.
Okay.
And then there's
Do we
a
have any
10
other business?
We do not.
Need to hear from anybody who wants to speak on the red soils matter, who may have appeared late.
Oh, okay. Is anyone, I didn't see anybody come in, but anybody come in that wants to speak on the Red County Red Soils proposal? No? Okay. Thank you very much. We'll carry that forward. We can adjourn now. Thank you very much.
Next meeting?
Next meeting is 2 weeks.